In this video, we're going to examine a new academic study that is very much in the subject of law. Now, I think the way I've described it in the description of this video is fair. It's certainly a critique of the Lucy Letby case and the trial and some of the legal issues that surround it. So it's quite a lengthy paper. It's 31 pages. There are nearly 200 references in the paper as well. So I'm going to summarise it and go through the arguments that are contained within the paper in this video. So I'll show you firstly that this paper is entitled Expert Evidence in Criminal Law, Rethinking Reliability in England and Wales After the Lucy Letby Case. It's authored by Amel Al-Grani and Sarah Bennett, who are both academics working in Liverpool, and it was published by the Northern Ireland Legal Quarterly in volume 77. So there's quite a lot to get through in this paper, but I'm going to begin nevertheless by reading out the introduction, which provides the proposition of this paper. There's also an abstract, but I will leave that out because I will read the conclusion at the end. Few criminal trials in recent memory have so starkly exposed the tensions at the intersection of law and science as Rex versus Letby. The case concerning the conviction of a neonatal nurse, Lucy Letby, for the murder of 7 infants and the attempted murder of 7 others at the Countess of Chester Hospital turned heavily on contested medical and statistical evidence. In the absence of direct eyewitness evidence, expert opinion played a central role in interpreting a complex circumstantial case, effectively providing the framework through which the jury was invited to understand the alleged clinical events. It is precisely this reliance that renders the case so significant. While the Court of Appeal upheld both the admissibility of the expert evidence and the trial judge's directions to the jury, the case has nonetheless provoked sustained unease. Questions remain surrounding the reliability of the underlying science, the independence of expert witnesses, and the adequacy of the legal framework regulating them. The continuing scrutiny of the case, including a reported application to the Criminal Cases Review Commission and the anticipated publication of the Thirlwell Inquiry Report into systemic failings at the Countess of Chester Hospital, underscores that these concerns remain live. I suppose just as a moment of commentary here, I'm recording this after the Thirlwell Inquiry was delayed again. I don't think we're going to be seeing that report at all. I'm not going to go into the reasons for that at this point in time, but I think they just realise there's no way that they can release the report. These anxieties are not new. The relationship between law and science has long been marked by epistemic tension. So I'll discuss this word epistemic later on in the video. Writing in 1897, William Foster recognised the expert as both a product and a necessity of modernity, an inevitable response to an increasingly technical world, while cautioning that the perceived evils of expert evidence were often overstated and unlikely to be resolved through procedural reform. So it's interesting to know, even if you go back 125 years, this gentleman, William Foster, recognises that the world is becoming more technical, it's becoming more complex, and what was deemed essentially bulletproof or certainly satisfactory evidence and expert evidence previously was already being compromised. His pragmatic counsel to let well enough alone reflected a judicial tolerance of imperfection that continues to shape the law's approach. More recently, Paul Roberts has argued that the deeper difficulty lies in the law's misplaced confidence in science as an objective and determinate source of truth, obscuring the interpretive judgments, blind spots and limitations inherent in expert knowledge. This article uses the case of Letby as a lens through which to interrogate the conceptual and procedural assumptions underpinning expert evidence in English criminal law, asking whether the current framework remains adequate in an era of increasingly complex scientific litigation. The analysis proceeds over the next 3 sections. The first of these examines the facts of Letby and the controversy surrounding the use, scope and influence of expert medical testimony. In doing so, it demonstrates that the evidential difficulties raised by Letby are not anomalous, but instead reflect a persistent structural vulnerability in the criminal trial process when adjudicating complex scientific claims. The second section analyses the legal framework governing expert evidence in England and Wales, showing how the requirement of sufficient reliability operates in practice as a flexible and often permissive threshold shaped by judicial discretion and dependent on adversarial testing, despite its well-recognised limitations. The third section examines reform proposals from the Law Commission's 2011 unimplemented proposals to comparative developments such as the United States Daubert standard, I think that's pronounced Daubert, in fact, and civil law models of court-appointed expertise, advancing a structured programme of reform aimed at improving the transparency, consistency, and epistemic grounding of admissibility decisions without displacing the core features of the adversarial process. In doing so, the article advances a more conceptually rigorous and institutionally grounded account of expert evidence responsive to the epistemic demands of contemporary criminal adjudication. So, as you can perhaps imagine from that introduction, I'm not going to read out the whole paper because that would take an enormous amount of time. I'm going to summarise each section and explain what is argued in each section, and also go over some of the references that are made within this paper. What I'll also say as well is I'm not going to discuss the first section very much because a lot of it is stuff that we already know, but I'm just going to go over that briefly before we get into the deeper stuff that is very interesting. So this is the very first section of the main text, the Letby case, and this essentially talks about how recent developments have sharply divided opinion on the safety of the convictions. I think it's beyond sharply divided now. I think the majority of people know that this is an unsafe conviction, and most of the relatively small percentage that don't haven't examined the case. It mentions the input of Sir David Davis, there's some background to the police investigation, details of the medical allegations are outlined, details of the circumstantial case are outlined, and then there's some discussion of no medical experts having been called in the trial. Then moves on to discuss the appeal in this section, and this is where I'll begin my summary of this document. Again, I want to be relatively brief here because the appeal is water under the bridge. But this section discusses the four main grounds of appeal. Firstly, that expert evidence from our friend Dr. Evans should have been excluded or the jury directed to disregard it. The Court of Appeal, of course, dismissed this, finding that Evans was properly qualified and that any issues of bias were for the jury to assess. Of course, we saw a lot of that buck passing from the judge in this trial. Secondly, that there was no case to answer. I've discussed this in a video recently. They raised that again in the appeal, arguing that there was no case to answer at the close of the prosecution case, but the court ruled that there was sufficient evidence, including medical records, expert testimony, and Lucy's own notes for the case to go to the jury. So that was thrown out, as we of course know. And thirdly, the judge's direction that the jury did not need to be certain of the exact harmful act for each count was challenged, and the court ruled that the directions were appropriate given the complexity of the case. I mean, I consider that to be utterly farcical, but there you go. Finally, it was argued that the judge mishandled an alleged jury irregularity, but the Court of Appeal found that the judge had properly exercised discretion under the criminal practice directions. Lucy, of course, also sought to introduce fresh expert evidence from Dr. Xu Li, arguing that it had undermined the prosecution's air embolism theory, but the Court of Appeal refused to admit this evidence, finding no good reason it had not been presented at trial and concluding it would not have affected the safety of the convictions. Overall, the Court of Appeal rejected all grounds, praised the trial judge's management of the case, and held that the convictions were safe and that no arguable legal errors had been demonstrated, which is a very typical response from the Court of Appeal. So then we move on to this section, beyond the verdict, and this gives some background on the Dr. Xu Li panel, contextualises the Thirlwell inquiry, and gives some details of the ongoing police investigation, and it more broadly discusses the fact that these developments have renewed and intensified scrutiny of the role, reliability and regulation of expert testimony in criminal trials, reinforcing the concerns that lie at the heart of this article. So then it really gets on into the meat of the arguments, which, as you can probably tell from those early sections, very much focuses on expert evidence, whether or not it's admissible, whether or not it's of an acceptable standard, and so forth. And that begins in this section: the law on admissibility, common law foundations, and procedural overlay. So the main argument of this section is that the treatment of expert evidence must be understood through the deeper conflict between how science and law produce knowledge. Science works through testing, revision, and uncertainty. Criminal law requires final binary decisions. So something of a conflict there inherent in that there is this uncertainty as is described in science, whereas I suppose there can be an element of uncertainty in a criminal law case, because if someone is found not guilty, then it's not saying that they're definitely definitively innocent. It's saying that there is a degree of doubt over the conviction, but it nevertheless requires these binary decisions of yes, no, in, out, etc., which is not the case with science, because science is constantly evolving and is simply far more complex than giving a binary decision. When expert scientific evidence enters court, judges and juries must turn uncertain probabilistic conclusions into definite legal outcomes. The admissibility rules exist to manage this epistemic mismatch. Essentially, this is arguing that there is a contrast and conflict between the nature of law and the nature of science. So as I mentioned, I will just define this term epistemic because it's not very commonly used. It's an adjective that relates to knowledge or the conditions for acquiring it, derived from the ancient Greek word episteme, meaning knowledge or understanding. It describes things related to how we know what we know, the limits of understanding, and the justification of belief. Essentially, this is about the theory of knowledge. And it's often discussed in philosophy, but as noted here, it can relate to everyday societal discussions as well. So epistemic just really is about how we can understand something, whether we can understand something, how we acquire knowledge, and so forth. So then the paper moves on to discuss the legal test of sufficient reliability, which is supposed to bridge the gap mentioned between science and legal proceedings, and the authors observe that this works inconsistently. Courts aim to admit only expert evidence reliable enough to assist fact-finding, but in reality, reliability is judged unevenly and often deferentially. So I feel that we've seen that in the past in many cases, but here, every attempt to say this gentleman is not an expert, in the case of Dr. Evans, is thrown out consistently. And it's argued, well, he's a qualified doctor. As we're going to see later on in this paper, his evidence can help the jury. He's been in court many times previously. So there's a kind of deference immediately to his previous experience. And not, in my view, and I think most people would agree, certainly I think most scientists and medics would agree, not a very worthy assessment of his actual medical and scientific credibility. Anyway, so it continues. Judges still rely heavily on discretion and adversarial challenge rather than strict independent scrutiny. This means questions that are really about knowledge and scientific validity are often treated as procedural trial issues instead. So we saw that in Lucy's case. We saw, for example, just to give one obvious example, the defence not unreasonably tried to have Dr. Evans excluded, and the judge decided, well, the jury can decide whether or not he's a credible expert. In my view, that's fundamentally ducking his responsibilities, because Dr. Evans should arrive in court as an expert, and that shouldn't be in doubt. To say, the jury can decide whether or not he's any good is ridiculous. The jury's not qualified to do that. And anyway, that's not really what's being tested in the courtroom. What's being tested in the courtroom is whether or not Lucy Letby's guilty of these allegations. Then there isn't going to be some deep process that examines whether or not Dr. Evans is a credible medical or scientist. So that's a classic example of a judge relying heavily on discretion and adversarial challenge rather than strict independent scrutiny. So I've mentioned here that there are numerous examples from the Lucy Letby case of Judge James Goss leaning back on this tendency to trust the jury and allow the jury to make decisions which they should not reasonably be expected to make. So then the article goes on to discuss common law. Common law developed formal rules for admissibility based on necessity, competence and reliability, but reliability remains loosely defined. So common law is just one branch of the law in this country, and I asked an artificial intelligence program to draw up this diagram. If you see me attempt to draw things, then you'd know that I couldn't do this. So there's common law, statute law, equity, as international other sources. The relationship between all these various strands of the law in the UK is extremely complex. And when you, for example, hear witness them talking about common law, that doesn't apply in all circumstances. Sometimes a different type of law applies. As you can see, these can relate to criminal law, civil law, public law, private law, and then there's various other aspects to it. But common law is just one strand that determines the overall legal system in Britain, which is enormously complicated in my opinion. So there are two critical papers referenced by the article at this stage. The first one is Rex versus Turner from 1975, which decreed that expert evidence is only allowed when the issue is outside ordinary jury knowledge. So Judge Goss could have very clearly drawn on this ruling. He could have decided, well, clearly what's being discussed here is outside the knowledge of ordinary jury members, and therefore we need experts, and clearly Dr. Evans is more qualified than the jury, so therefore his evidence is allowable. In this particular ruling, the Court of Appeal set out one of the leading common law principles on expert evidence, that expert evidence is admissible only where it provides the court with information likely to be outside the experience and knowledge of the judge or jury. If the jury can reach its own conclusion using ordinary common sense and everyday experience, expert opinion is unnecessary and should be excluded. So that can immediately provide justification for the inclusion of Evans, because clearly the jury can't just use ordinary common sense to assess the Lucy Letby case because of the complexity of the evidence. In this case, Turner was charged with killing his former girlfriend and wanted to rely on psychiatric evidence. The psychiatrist proposed that because of emotional stress and his personality, he reacted in a way that was understandable for an ordinary person under strain, but the Court of Appeal ruled that this was not adequate expert evidence because jurors would not need a psychiatrist to tell them how an ordinary person would react to jealousy, reaction, anger, or emotional pressure. And there was this observation: jurors do not need psychiatrists to tell them how ordinary folk who are not suffering from mental illness are likely to react to the stresses and strains of life. So, examples of where the Turner rule could be applied, immediately the first one that's picked out is neonatology. There's also pathology, DNA analysis, accident reconstruction, psychiatric disorders, engineering failure, other very specialist areas. But given that this court case patently involves neonatology, there was always a likelihood that, I suppose, that Judge Goss would allow Evans to remain in the court case. The next one is Rex versus Bonython from 1984. This is a two-stage test. The field itself must be sufficiently reliable and organised, and the witness must genuinely be an expert in that field. So this is a scenario where you see there may have been potential to exclude Dr. Evans because we know he's not really an expert in neonatology. And in these kind of complex infant cases, very vulnerable infants, it's arguable, I think it's reasonable to say he probably never was an expert in that field, but he certainly wasn't at the time that he gave evidence in court. And he shouldn't have been allowed to work as an expert witness at that time. Too long had elapsed from when he worked in a hospital, and he shouldn't have been part of the system. But that's a failing of the system, unfortunately. So this is actually an Australian case from the Supreme Court of South Australia that established this practical two-stage test of whether the subject matter is a proper field for expert evidence and whether a particular witness is sufficiently qualified in that field. The court asked whether the proposed expertise belongs to a body of knowledge or experience which is sufficiently organised or recognised to be accepted as a reliable body of knowledge or experience. The court must ask, is this a real field of expertise or just speculation dressed up as science? The discipline must be something more than personal opinion or unsupported theory. So you can see there was clear potential for Goss to exclude Evans, but he just couldn't understand that this was, to a very great extent, personal opinion. This was, to a very great extent, unsupported theory. It was speculation dressed up as science. This is almost a perfect description of what it was. But unfortunately, because of his credentials, because he'd worked in court a lot, because he presented himself a certain way, because I believe fundamentally there was a reluctance to exclude him because it would have led to a mistrial. It would have led to the case collapsing immediately, and that would have been hugely embarrassing for everyone involved. So I still think that fundamentally that is the reason. But under these circumstances, you could see how someone might think, well, Dr. Evans has been a paediatrician. He said he was instrumental in neonatology in Swansea. He said this, that, and the other. He's been in numerous court cases. He's given evidence lots of times. He's an expert. Neonatology is a real field of expertise, and he can legitimately be considered an expert within that field. And what could have strengthened that impression was the fact that you had a neonatal unit with no neonatologist. It's not like you could say, well, you have to be a neonatologist to work in neonatology, because they had this phalanx of paediatricians that had been running the neonatal department in Chester. So a lot of confusion could have been derived from that as well, I feel. So I just wanted to point out as well that there's this moment in court where the defence say in relation to the evidence, we have to be careful of the assumption or theory of guilt and the dangers of opinion in relation to the conclusions of deliberate harm. We say that if an expert sets out with expectation a suspicion of harm being done, that may make it more likely they will reach conclusions which are harm-based rather than innocent explanations. When there is no explanation, there is a danger of the expert filling the absence of an explanation with one by the prosecution. So you would hope it wasn't necessary for Ben Myers to say that in court, but of course it was necessary. And he probably knows that himself from times that he's represented the prosecution, indeed. So just a few examples to go back to the previous section, that junk science, unsupported behavioural profiling, speculative syndrome evidence, personal intuition, presented as expertise, or methods lacking recognised scientific foundation should fail stage 1. Now, there were numerous opportunities for the science in this case to fail stage 1, and it didn't. And I think the simple reason for that is lack of knowledge and understanding on behalf of the judge. And I believe that ultimately he just would never have thrown Evans out the court because it would have made the criminal justice system look ridiculous, as I've said numerous times. The stage 2 then is supposed to be, is the witness actually an expert? So I'm not going to read through all of this because in Lucy's case, this comes down to this dichotomy between ostensibly Evans is an expert because he's a qualified doctor, it's a specialist area, he presents himself as being a consultant paediatrician even though he isn't, because it's a long time since he's worked in paediatrics and so forth. Whereas the actual reality is that he's just not up to the job, really. I think most people would agree with that. But he can appear like an expert to the court. There are other issues as well that I think even this stage can't address, really, which is that if you've got an expert who wants to give definitive views on things and who is invested in winning, then what can the court do about that, and what can the judge do about that? Can the judge even recognise that? It seems easy to us now, but would it be possible for the judge to recognise that? I don't know. So then the paper itself goes on to state here, I'm not going to look at these cases, Luttrell and Dlugosch, but they refined this process of modern technical evidence, the stages that we've gone over previously. However, despite more references to reliability, courts still do not apply this rigorously. In practice, courts usually admit expert evidence too easily by trusting qualifications rather than testing methodology. Judges often focus on the expert's credentials and experience rather than whether their reasoning is scientifically sound. Exactly what I've just explained to you, this dichotomy. It seems to me that the two ladies who've written this paper understand this case extremely well. This is called epistemic deference, trusting authority instead of examining reliability. The threshold for admissibility is therefore quite permissive. And then this section goes on to say or argue that procedural reforms have improved transparency, but they have not solved the deeper problem that reliability is still mostly left to adversarial challenge at trial, as indeed occurred in this case. It's so often the instinct of the judge, based on the Lucy Letby case at least, to believe that, there'll be a court process, the prosecution will argue one thing, the defence will argue another thing, and the jury will make their mind up, and the ultimate decision will be correct. Which to me seems, the more I look at this case, the more I believe that to be increasingly farcical. Crim PR 2020 and the criminal practice directions require experts to explain methods and limitations more clearly. However, courts still rarely examine the scientific foundations closely unless another expert challenges them. Cross-examination is often too weak to test complex scientific evidence properly. The system assumes weaknesses will emerge during trial, which is risky in specialised cases. As a result, admissibility rules often postpone rather than solve epistemic problems, raising concerns about the limits of expert testimony. And I'm sure none of that needs any further explanation for people that know the Lucy Letby case, because I'm certain that you can all recognise the relevance of all of these assertions. So I'm going to summarise this section because it was quite long and complex. Expert evidence law exists because science and criminal law operate differently. Science accepts uncertainty and revision, while criminal trials require a final binary verdict of guilty or not guilty. Admissibility rules try to manage this tension. Courts use the idea of sufficient reliability to bridge this gap, aiming to admit only expert evidence reliable enough to help fact-finding, but in practice this standard is applied inconsistently and often depends heavily on judicial direction. Rex v. Turner established that expert evidence is only admissible where the issue is outside ordinary jury knowledge. If jurors can decide using common sense, expert opinion should be excluded. Rex v. Bonython added a two-stage test. The field itself must be a recognised and reliable body of knowledge, and the witness must be genuinely qualified as an expert in that field. Although later cases such as Luttrell and Dlugosch refine the law for modern scientific and technical evidence, reliability remains loosely defined, and courts often admit evidence too readily by trusting qualifications rather than closely testing methodology. Procedural reforms under the criminal procedure rules and criminal practice directions have improved disclosure of methods and limitations, but reliability is still largely left to cross-examination at trial, meaning admissibility often postpones rather than resolves deeper epistemic problems. So then the next section is this, the nature and function of expert evidence, renewed scrutiny. So this section argues that the legal framework governing expert evidence in criminal trials is conceptually strained and increasingly outdated. It begins by explaining the traditional distinction between fact and opinion evidence. Ordinary witnesses are confined to facts, while expert witnesses are allowed exceptionally to give opinion evidence where specialised knowledge is needed. So the massive problem as well you had in the Lucy Letby cases, you have the opinion evidence coming from, as is described here, experts that are allowed to give opinions where specialised knowledge is needed, and then you have the factual evidence coming from people who worked at the hospital who weren't up to the job that they were actually required to do, and so therefore the factual information they gave was flawed as well. So all the court heard was a lot of very flawed information. So I'll continue with the summary here. However, it then highlights Paul Roberts' critique that this distinction is unstable. In practice, much testimony involves interpretation, and expert evidence often blends factual material with evaluative judgment, especially in medical and forensic contexts. This makes the fact/opinion divide and its framing as a narrow exception misleading and overly simplistic. The text further argues that this artificial categorization obscures the real nature of expert evidence, which frequently involves the presentation and interpretation of specialized facts rather than pure opinion. As a result, the doctrinal framework fails to reflect the complexity and diversity of modern expert testimony. It then shifts to emphasize the continuing necessity of expert evidence in modern trials. Scientific and technical expertise is described as essential for accurate decision-making in areas beyond ordinary knowledge. This need is especially acute in complex criminal cases, such as the Lucy Letby litigation, where judges have acknowledged that the medical evidence could not be properly understood without expert assistance. Finally, the passage notes attention. While expert evidence is indispensable, its increasing use has raised concerns about reliability, independence, and proper weight. These issues feed into broader doctrinal and institutional debates about how expert evidence should be regulated and evaluated in criminal proceedings. So I guess to summarise that, this section simply brings forward several arguments questioning whether the current system for expert evidence, and therefore the expert evidence itself, is satisfactory and competent. And then the next section in the paper is this one, assistance and the boundaries of expertise. This passage examines the legal requirement that expert evidence must assist the court, arguing that this standard is important but difficult to define and enforce in practice. This is an absolutely key phrase, this notion that expert evidence is assisting the court. It explains that English law permits expert evidence where a witness has specialised knowledge beyond that of the jury, as established in cases such as Rex versus Silverlock and Rex versus Turner. This is now supported by the criminal procedure rules and related guidance, which require expert evidence to be relevant, reliable, and provided by properly qualified individual. Experts must set out their qualifications, but the law does not impose strict minimum credential requirements. Very important, of course. So essentially means, oh look, you've got some credentials, that's fine, you're an expert by definition, which is exactly what we've seen occur in the Lucy Letby case. So the two cases mentioned, firstly Rex versus Silverlock. This is a very old case from 1894, but it established that you do not need formal academic qualifications to be an expert. So it actually gives the example here of Silverlock. A solicitor was allowed to give handwriting evidence because he had extensive practical experience. So I guess that I would consider myself to be an expert on language. I suppose that I could give court evidence in that area if it was needed. Experience can come from experience in practice, not just degrees or titles. So then that further cements the notion that if you've appeared in court a lot, you are an expert. And then Rex versus Turner sets out the limits of expert evidence, confirming that expert evidence is only admissible when the issue is outside the ordinary knowledge of jurors. We, of course, dealt with this earlier in the video. These two cases establish a combined rule. The witness must have real specialised knowledge or experience, and this knowledge must be beyond ordinary jury understanding. And expert evidence is only admissible when both are satisfied. The problem with this is that, as mentioned, because the bar is set quite low for the notion of specialised knowledge, and because almost all specialised knowledge is outside ordinary jury understanding, that means almost anyone that puts themselves forward as an expert is going to be accepted, particularly if they've appeared in court more than once. Once you've broken that initial barrier and you've appeared in court, you're going to be invited back as an expert again and again and again. And this is what's happened with Dr. Evans, of course. The duty of an expert witness I wanted to discuss here, because this is mentioned in this passage as well. This is to help the court achieve the overriding objective by giving opinion which is objective and unbiased in relation to matters within their expertise. This is a duty that is owed to the court and overrides any obligation to the party from whom the expert is receiving instructions. See Criminal Procedure Rules 2020, Part 19. So if you look at these directives, I've just highlighted a couple of things that can, it says here, should be disclosed by all experts under Crim PR 19.2 bracket 3. These include adverse judicial comment. So obviously, Dr. Evans has had pretty much the most adverse judicial comment that is possible. And any case in which an appeal has been allowed by reason of a deficiency in the expert's evidence, this had also occurred previously for Dr. Evans. So you see, despite the existence of this, and I will say this is the most recent version of the Criminal Practice Directions, I don't know for certain that it was in place in this format when the Lucy Letby case began, although it's very likely that it was. But these would have been two reasons that Dr. Evans could have been excluded immediately. And then another one is a history of failure to adhere to the standards expected of an expert witness in the criminal justice system. Now, I don't think this applies in advance of the Lucy Letby case, but we've seen the kind of conduct of certain witnesses in the case following the conviction. I don't believe that has been up to the standards that should be expected of an expert witness. Certainly, when I heard the term expert witness, I had a very different impression of what that would constitute compared to certain witnesses that appeared in the Lucy Letby case. The text then highlights a key weakness in the system. Formal qualifications do not guarantee genuine expertise or reliable methodology. The case of Jean Morrison illustrates how an individual with real qualifications was able to give expert evidence in hundreds of cases over decades. Broader research also links a significant proportion of miscarriages of justice to false or misleading forensic evidence. So this gentleman, Jean Anthony Rocky Morrison, is a convicted sex offender and former fraudulent forensic detective who operated over 3 decades in the Hyde area of Greater Manchester, England, under the title Dr. Jean Morrison. This was relatively recently. He was born in 1958. He eventually went to court himself in this century, about 2006-2007. He was able to trick not only members of the public, but also many judges, lawyers and the police themselves into believing he was a genuine expert in forensic science, which doesn't really bode well, you'd have to say. And then the text continues. It further shows that even highly qualified experts can give flawed or misleading testimony. The case of Sally Clark demonstrates how Professor Sir Roy Meadows' statistically incorrect evidence contributed to a wrongful conviction later overturned when new medical evidence emerged. Although he was initially sanctioned professionally, the court later found that an honestly held but mistaken opinion did not necessarily amount to misconduct unless dishonest or reckless. So I don't think I need to go over that in any depth. I think we're all very much aware of Sir Roy Meadow and Sally Clark by now. The passage then focuses on the problem of expert overreach, where experts exceed their proper role by straying into legal judgment, advocacy, or presenting contested views as settled fact, crossing the boundary between assisting the court and influencing it improperly. So I'm sure you can all see the relevance of this passage in the Lucy Letby case. Finally, these concerns are linked to ongoing controversy in the Lucy Letby case, where questions have been raised about the scope, independence and experience of prosecution experts. Although appeals have not succeeded on these grounds, such criticisms reflect wider concerns about whether the current safeguards are sufficient to ensure expert evidence is objective, reliable, and properly constrained. It seems to me that it very much is not. Then the next section is impartiality, the duty to the court. And this begins by arguing that alongside the requirement that expert evidence must assist the court, a further core principle is that experts must be independent and impartial. Under the criminal procedure rules, experts owe an overriding duty to the court to provide objective and unbiased evidence regardless of the party instructing them. However, the text emphasises a persistent tension between this ideal and the realities of adversarial litigation. Because experts are chosen and paid by opposing parties, there is an inherent risk of conscious or unconscious partisanship. Drawing on historical and modern commentary, including Learned Hand and Paul Roberts, it suggests that the adversarial system can turn experts into hired champions, where scientific analysis may be shaped, intentionally or not, by the needs of persuasion rather than truth. So again, I'm sure you can all see the relevance of this to the Lucy Letby case, and I really commend these two authors for really knowing the case rather well, based on what they've put into this paper. So the paper that's been referenced a few times by Roberts is this one by Roberts and Zuckerman, published in 2022, which provides a systematic and contextualized introduction to the principles of criminal evidence and trial procedure. And the Harvard review, also mentioned in the previous section, is here. Historical and practical considerations regarding expert testimony, a very highly regarded but quite old review now. This was from 1901 by this. So Learned Hand, that sounds like it'd be a publication, but it's actually the name of a person. And this article by Learned Hand, that's his middle name and surname. I think his name's Billy, if I remember rightly, but we're going to come on to that in a second. Historical and practical considerations regarding expert testimony is a very early but influential critique of how courts use expert witnesses, particularly in adversarial systems such as the United States and England. At its core, Hand is worried about a structural problem. Experts are not neutral truth tellers. Once they enter litigation, they become part of the adversarial contest. And I think we see that very clearly in the example of Dr. Evans. And so Hand argues that experts are necessary but dangerous. Modern trials, he's writing about this in 1901, often involve technical questions, medicine, engineering, science. Judges and juries cannot evaluate these issues without assistance, so expert testimony is essential. But Hand argues this necessity creates a risk. Courts become dependent on outsiders whose evidence is hard to evaluate critically. And also the adversarial system distorts expertise. Because each side hires and pays its own experts, there is a natural pressure, sometimes subtle, sometimes explicit, for experts to emphasise interpretations favourable to the instructing party, downplay uncertainty, and present contested scientific opinions as firmer than they really are. Now, sadly, Mr. Hand isn't with us anymore, but when he was writing this in 1901, I'm sure he would have been fascinated to see the court proceedings of Lucy Letby, because he has absolutely anticipated all of the problems that we have viewed, that we've experienced in this court case. Then Hand is not necessarily accusing all experts of dishonesty. Instead, he highlights selection effects and confirmation pressure. Even honest experts may unconsciously lean towards the side that employs them. Juries are poorly equipped to resolve expert conflict as well. When two experts disagree, the jury is often left choosing between competing credentials rather than evaluating the underlying science. Hand sees this as a weak epistemic foundation for fact-finding. Of course, it was worse in this case because they didn't have competing experts. Then finally, he talks about the hired champion. Hand anticipates what modern commentators still describe. Experts can effectively become advocates in scientific clothing shaped by litigation strategy rather than independent inquiry. So you can see why this 125-year-old paper is so influential and so prescient. So I apologise to Mr. Hand, but his name is Billings, not Billy. He was a judge of the US Court of Appeal for the Second Circuit. You can see he would have been enormously influential. So I think in the dim and distant past of the court system, my impression is there was more of an idealistic outlook. It certainly seems that way from what I've seen, from those that work within it, whereby they really cared about the law being accurate and an arbiter of truth. And then as it's developed, the law has become more of a lucrative profession that people go into, and increasingly they seem to care about protecting the hand that feeds them in the system itself, rather than any arbitrary concepts such as truth or justice. Now, of course, that's not universally true, but it does seem like an overarching theme. Those that work in the criminal justice system now, particularly at the apex of the system, appear far more committed to the system itself than what most people would understand by the term justice. And you see on the screen now some examples of this, some of the institutional incentives, procedural constraints, financial and career pressures, and increasingly as well, we've put this system on a pedestal. So then I think people that work within the system, similar to consultants, I suppose, believe they have some sort of supernatural ability, or else, develop ego problems. So the next section of the paper argues that this structural concern we've discussed is reinforced by academic commentary and empirical research, which suggests that confirmation bias, financial dependence, and adversarial pressure can undermine neutrality. Francis Goodall describes this dynamic as allowing experts to present evidence in subtly persuasive ways while still appearing compliant with procedural rules. And then it uses the Lucy Letby case as an illustration of these issues, noting that the prosecution expert Dowie Evans asserted his independence but had also shown prior interest in this investigation. Of course, we all know about that. Although the Court of Appeal held that his dual role as both investigator and expert did not disqualify him, the text argues that such overlapping roles risk blurring the line between independent expertise and prosecutorial alignment, especially in the absence of clear procedural safeguards. I think it seems to me to be a fundamental problem that you can work with the prosecution and then go in court and be deemed an expert on what you have just prepared for the prosecution effectively. Again, seems farcical. And then finally, the text points to survey evidence suggesting that hired gun experts still exist in practice, with some experts perceived as tailoring their opinions to support the instructing party. This is obviously phrased delicately, but I think we can see what they're stating here. Overall, it concludes that adversarial incentives continue to challenge the ideal of independent expert evidence, placing strain on courts' ability to act as effective gatekeepers of reliability and impartiality. So I'm sure you can see where many aspects of that relate to the Lucy Letby case. Then we move on to this section, admissibility and judicial discretion and interpretive variance. So this passage argues that although the criminal procedure rules and criminal practice directions require expert evidence to be relevant, competent, and sufficiently reliable, these standards are vague and give judges wide discretion. As a result, admissibility decisions are inconsistent, and issues like bias, methodology, or limits of expertise are often treated as matters affecting the weight of evidence rather than whether it should be admitted at all. So we saw that again in the Lucy Letby case, where there were issues related to admissibility and the judge just allowed these things to go into the court case. The judge used this wide discretion that is described here. It notes that case law and guidance, e.g. Henderson, encourage judges to consider factors such as an expert's current practice and experience, but these criteria are applied unevenly. Thus, despite concerns about Dr. Evans' retirement, lack of recent clinical practice, and investigatory involvement, his evidence was admitted because the court considered he could still assist the jury. This reflects a pragmatic rather than strictly methodological approach to reliability. So we're going to take a look at what is said in this Henderson reference that's made here and we'll see this illustrated by that study. So Henderson, in this particular case, the Court of Appeal considered how trial judges should approach expert evidence admissibility, particularly where the expert's experience or practice may be outdated, there are questions about ongoing competence, the expert is still arguably capable of assisting the jury despite imperfections. The key issue was not just, is this expert perfect, but is this expert sufficiently reliable and helpful for the jury to hear them at all? So if we look at the criteria outlined in Henderson, this study is looking at the expert's qualification and experience, whether their expertise is still current or has become stale, the extent of their involvement in the relevant field, and whether any weaknesses go to admissibility or simply weight, how much the jury should trust them. And it says here, crucially, even if an expert has limitations, that does not automatically make their evidence inadmissible. So, in the case of the primary prosecution witness in this Lucy Letby court case, not a neonatologist, if we look at point 1, so immediately doesn't really have the qualifications, hasn't really worked with neonates, and hasn't worked with anything like the gestation and general acuity that was involved in these indictment infants. Then on point 2, whether their expertise is still current, well, obviously not, because Dr. Evans hasn't worked in a hospital for a very long time. It would be quite reasonable, in fact, I think it'd be generous to describe his expertise as stale at this point. Then, of course, on top of that, we're not looking at a top neonatologist. We're not even looking at a neonatologist. We're looking at a paediatrician. Now, again, I probably mentioned earlier, one of the problems here is that judge can look at a neonatal unit that's entirely staffed by paediatricians, so he might not understand the significance of this, even if he would have been inclined to take it into account anyway, which is doubtful. And then when we look at point 3, the extent of Dr. Evans' involvement in the relevant field, really his involvement in neonatology has been minimal over his career. And certainly he's not qualified in neonatology. So these should have been major weaknesses that, obviously, in an ideal world, if you were picking the most qualified person to give evidence, he would be nowhere near, absolutely nowhere near. The only reason he's in the courtroom is because he's on the NCA list. It's as simple as that. And that's even despite the fact that he's had this worthless case, and then on top of the worthless case, his Northern Ireland case, and on top of that another case, and on top of that another case. So that should have been blotting his copybook quite significantly, but of course it wasn't, and the judge still allowed him to be in the court because of this admissibility versus weighting argument. So it is noted here that modern law encourages judges to screen expert evidence for relevance, reliability, appropriate expertise, which suggests a gatekeeping function. But Henderson demonstrates that courts often take a low threshold approach. Concerns about retirement or lack of recent practice, methodology or investigative involvement often go to weight, not admissibility, which is exactly what happened in this case. So what occurred is that what is outlined in this study by Henderson was absolutely reflected in what Judge Goss decided to do in the Lucy Letby case, even though there was an extraordinary situation a very strong argument to exclude Dr. Evans. But as I've said before, and as I'll repeat again, I don't think he was ever going to throw him out unless there was an extraordinary situation, because he would have had to stop the trial halfway through. And he was just never going to do that because, you know, he's a man of the system, and they don't like to do this kind of thing. They don't like to do things that show up the criminal justice system, even when it's glaringly obvious that something is wrong, let alone a situation like this where, because of these weight and admissibility arguments, Judge Goss could make the argument that, oh, you know, well, it's up for the jury to decide whether or not he's a relevant expert. For me, farcical, but it was allowed. It has been allowed previously, and courts often take what is described here as a low threshold approach. So it is noted here that modern law encourages judges to screen expert evidence for relevance, reliability, appropriate expertise, which suggests a gatekeeping function. But Henderson demonstrates that courts often take a low threshold approach. Concerns about retirement or lack of recent practice, methodology or investigative involvement often go to weight, not admissibility, which is exactly what happened in this case. So what occurred is that what is outlined in this study by Henderson was absolutely reflected in what Judge Goss decided to do in the Lucy Letby case, even though there was a very strong argument to exclude Dr. Evans. But as I've said before, and as I'll repeat again, I don't think he was ever going to throw him out unless there was an extraordinary situation, because he would have had to stop the trial halfway through. And he was just never going to do that because he's a man of the system, and they don't like to do this kind of thing. They don't like to do things that show up the criminal justice system, even when it's glaringly obvious that something is wrong, let alone a situation like this where, because of these weight and admissibility arguments, Judge Goss could make the argument that, well, it's up for the jury to decide whether or not he's a relevant expert. For me, farcical, but it was allowed. It has been allowed previously, and courts often take what is described here as a low threshold approach. / Kafkaesque situation in which someone can give scientifically incorrect information in court, and the weaknesses of that evidence and the weaknesses of that witness can be revealed so that the judge is made aware of this, and the judge can still say, but that scientifically incorrect information will assist the jury. So the passage goes on to say that the courts sometimes infer expertise informally, for example in Rex versus Clear and Peach, prioritising usefulness over rigorous validation. This has led to concerns that unreliable or weakly grounded expert evidence may be admitted too easily, especially in complex scientific cases. I think we can all agree with that. So this case, Rex versus Clear and Peach, the court accepted opinion evidence from a witness whose expertise was not established through a highly formal or rigorous demonstration of qualifications. Rather than conducting a strict inquiry into methodology, training, or peer validation, the court effectively treated the witness as sufficiently expert because their knowledge appeared to assist the jury. So this is fairly recent, again, 1995. So at least in the Lucy Letby case, the judge can say, but Dr. Evans was a consultant paediatrician. He'd worked on the paediatric unit. He claimed he'd worked in neonatology. He claimed he was involved in setting up the neonatal unit in Swansea. He'd been in lots of court cases previously. He'd always given evidence in relation to being a consultant paediatrician. This guy absolutely meets the requirement for being an expert. In fact, in this case, the court treated someone as an expert who didn't have the qualifications, who wasn't an expert by even kind of loose definition. But the court said, don't worry, this person's assisting the jury, so it's fine. There's then in the paper some discussion of reform efforts, including this Law Commission 2011 proposal that we've mentioned previously on the channel. This is a statutory admissibility framework with clearer reliability thresholds and pre-trial screening, but the government chose not to implement this, instead incorporating limited reforms into procedural rules. These changes improved transparency but left judicial discretion largely intact, let's just say entirely intact. So this is the Law Commission recommendations from 2011, expert evidence in criminal proceedings, which are very extensive. So this was published in March 2011, recommending changes to the admissibility of expert evidence in criminal proceedings. This finalised a 3-year review recommending the simplification of adult social care law, which helped form the basis for later legislative reform. They opened a consultation in January 2011 on marital property agreements. There was a joint consultation paper published with the Scottish Law Commission, and so on and so forth. This is all essentially irrelevant because the government response to the Law Commission report, published a couple of years later, was to reject it. This was a 15-page response, not enormously detailed, but it goes into some detail. I just wanted to really highlight this point, that it would have cost £7 million or £6.9 million over 2 years, and the government concluded it would be better to allow the existing arrangements to continue before considering spending this money. So I think there's about 35 million taxpayers in the country, so it would have been 20 pence each, but they couldn't afford that because it was deemed a waste of money. Think of all the money that's been spent on the thermal inquiry, on this court case, and not to mention all the other things that there's an enormous amount of waste in. We know there's a lot of waste in the NHS. Billions spent on these maternity cases, but they couldn't shell out £7 million to improve or potentially improve the way that the judicial system works. So the paper continues, commentators argue that this creates an implementation without legislation problem. Judges are still left to decide what sufficient reliability means without clear epistemic tools or standards. In Letby, for instance, reliability was effectively assessed through experience and presentation rather than methodological scrutiny. And I do think that, broadly speaking, judges do face significant challenges in deciding whether an expert is suitable or not, particularly as they're vetted by the National Crime Agency. However, in this case, there was a pretty big clue from the fact that this previous trial judge had described Dr. Evans' report as worthless and said that he made no effort to give a balanced opinion. So we continue. Overall, the passage concludes that the current system lacks a clear and consistent reliability threshold. Judicial discretion remains the main safeguard, but it is uneven and dependent on individual judges' understanding of science and expertise. As a result, reliability risks becoming an elastic concept, undermining consistency and raising concerns about the robustness of safeguards against flawed expert evidence. So this is really just essentially saying the system doesn't work. Experts can give flawed evidence in court, and there is basically no fail-safe mechanism to protect against that. So now go on to this section, reform debates and comparative models. This begins by considering whether adversarial systems should be replaced or supplemented with court-appointed experts to improve the handling of complex expert evidence. It explains that scholars such as Kenny and Spencer, drawing on criticisms such as those of Learned Hand, agree that adversarial trials struggle when experts disagree and suggest inquisitorial-style reforms where neutral court-appointed experts are used instead of partly appointed ones. While systems such as France and Germany use this model, Roberts is sceptical about adopting it in English criminal law. So there's some interesting discussion here in this next remainder of this study of this dichotomy between the adversarial and inquisitorial systems. I suppose I should just remind people that Lucy Letby was convicted in an inquisitorial system, so we shouldn't hold them up as being some sort of silver bullet, because they definitely are not. And actually, someone has recently alerted me to one of the problems with an inquisitorial system that I will discuss later in this video. So the text continues to argue that the court-appointed experts would only improve clarity if they replace rather than simply add to party experts. Otherwise, courts could face a confusing three-cornered battle between prosecution, defence and court experts. Even in inquisitorial systems, however, the passage stresses that court-appointed experts are not a perfect solution. They can become authoritative figures whose views are rarely challenged, creating institutional bias instead of adversarial bias. So this is an important point. So there'll be further discussion, I believe, in this study of the inquisitorial system. But one of the issues that was pointed out to me by a very intelligent and qualified person recently was that if you have a kind of blanket consensus, or even a majority, very high majority consensus on a particular issue or a particular form of science, it can then be difficult to get experts to disagree with that, let alone get them to disagree with that in court. So an obvious example of this would be shaken baby syndrome. It's already difficult now, even in a adversarial system, to get experts to argue against that. But if you had a broad consensus among experts, it could become even harder. If you imagine from this case, imagine somehow in some horror scenario that air embolism became accepted by a consensus of experts that any time there was discoloration, that means it's air embolism. That could be absolutely disastrous. Now, it's hard to imagine that occurring, but that is one of the dangers of an inquisitorial system, is that it's great to have court-appointed experts, potentially, and it's a good thing to have experts of a higher standard, but if they are all of the same opinion, and if an opinion becomes established on a certain area of science, that can then be inserted into court cases repeatedly without ever being examined adequately, as would occur in an adversarial system. Indeed, the study notes that comparative research shows that inquisitorial systems are also vulnerable to wrongful convictions and uncritical reliance on official experts, meaning procedural design alone does not guarantee reliability or fairness. This leads to the idea of epistemic humility. No system fully solves the problem of expert fallibility, and all are prone to different forms of bias. I think we can all agree with that. There's never going to be a utopia. Finally, Roberts argues that moving away from party-led expert evidence could undermine core adversarial safeguards, particularly the accused's right to challenge prosecution evidence through independent experts. A single court-appointed expert could therefore threaten fairness and judicial neutrality. So again, from Lucy's case, think about the insulin cases. Now, she didn't get a very good hearing on this anyway, but let's say there had been a broad consensus that high insulin, low C-peptide equals automatic exogenous insulin, automatic poisoning, and then that became rubber-stamped. You know how the court system and the legal system loves precedent. So then there's the precedent. Or under any circumstances we see high insulin, low C-peptide, automatically it's exogenous. Pretty much we're looking at that anyway. But it could become even worse than it is now. Whereas at least as things stand, this new evidence, these new studies, this new understanding can be introduced, and hopefully things can improve. So there are definitely circumstances in which elements of an inquisitorial approach can improve things, but we shouldn't, as I mentioned, see it as this silver bullet that's going to solve things, because unfortunately that's not the case. So just to reiterate, I've created this diagram. What this essentially means if there was a consensus on something, particularly an expert or scientific consensus, drawing experts from outside this consensus, even if the consensus is wrong or potentially challengeable, could be difficult and it may in some circumstances be impossible, and this can in itself lead to wrongful convictions. So this passage concludes that wholesale reform towards court-appointed experts is neither necessary nor desirable. Instead, it recommends improving the existing adversarial system through stronger admissibility standards, better scrutiny of methodology, and enhanced safeguards for reliability and transparency. This study doesn't look at the police at all, but I should probably add to that I think specialist forces and specialist bodies within the police that investigate these complex scientific cases would certainly be, at the very least, advisable. Based on what I've seen from Cheshire Police, I would describe them as essential. The next section then is this accreditation and continuing practice requirements. This passage examines reform proposals aimed at improving the reliability of expert evidence through accreditation, professional regulation, and continuing competence requirements. It explains that earlier attempts at self-regulation, such as the Council for the Registration of Forensic Practitioners, failed because participation was voluntary, lacked statutory backing, and was inconsistently recognised by courts. Its collapse highlights the limits of relying on professional self-regulation alone. More recent reforms, including the Forensic Science Regulator Act 2021, strengthen oversight in forensic science, but do not establish a comprehensive accreditation system for all expert witnesses. The text argues that while accreditation could improve standards, it cannot solve deeper epistemic problems in evaluating expert evidence. Reliability depends not only on credentials, but also on the quality of reasoning, transparency of methods, and the way courts interpret and assess competing expert claims. Judicial evaluation remains central and inherently interpretive. The author therefore supports introducing a structured accreditation system combined with continuing competence requirements, but emphasises that this should be flexible. Courts should retain discretion to admit non-accredited experts where necessary, especially in fields with limited expertise or where retired practitioners still have valuable knowledge, as illustrated by the Lucy Letby case. So what they're essentially arguing here is that the calibre of expert and the calibre of evidence that is provided by these experts should go through a much more rigorous selection process. This passage also stresses the need for clearer safeguards around independence, particularly to prevent experts becoming involved in investigations in ways that may compromise neutrality. Transparency about conflicts of interest and pre-trial involvement is recommended. Overall, accreditation is presented as a useful but insufficient reform. It could help filter out poorly qualified or speculative experts, but it cannot replace rigorous judicial scrutiny. The core challenge remains ensuring that courts meaningfully evaluate the substance, methodology, and reasoning of expert evidence rather than relying on formal credentials as a proxy for reliability. So I think some excellent points made here, particularly in the final sentence. It's very clear that in this case, the Lucy Letby case, formal credentials were relied on as a proxy for reliability. And what this paper is calling on is for the scrutiny of experts to be meaningfully evaluated so that the evidence that they provide in court has real substance. So then the penultimate section is a pre-trial reliability hearing akin to a Daubert light model. So this passage argues that accreditation alone is insufficient to ensure reliable expert evidence because the deeper problem lies in how courts assess scientific validity at the admissibility stage. So what they're saying here is that the problem is that courts at the moment are poorly placed to understand science and understand whether something that is going to be presented in court has any scientific validity. It explains that English law currently relies on judicial discretion and adversarial testing to assess sufficient reliability. So instead of sifting out poor science and poor experts before the trial begins, they just rely on having a big argument in court. Now, it seems pretty obvious to me that it's almost like it's comical, isn't it? I mean, how the hell is obviously that leaves the system very vulnerable to poor science and to miscarriages of justice. It boggles the mind, really. But they have such faith in the system. Oh, but this all has probative value, that they'll say. Or, you know, the jury can ultimately make a decision based on what they've heard, and the jury can assess this, and the jury can assess that, and both sides have had the chance to cross-examine everyone. As if this is some sort of magic wand that produces automatic reliability. Of course it doesn't. So the document continues, but this approach is largely unstructured and depends heavily on disclosure rules and cross-examination. While Crim PR and the CPD require experts to set out their qualifications, methods and data, they do not provide judges with clear criteria or scientific tools to evaluate methodological soundness. So as I've said, I'll say it again, I don't think there's any prospect that the Goss can throw Evans out. However, he has got to sit there and just think, how do I even begin to assess whether or not this guy is an appropriate expert? And as mentioned previously, he just falls back on the fact Dr. Evans has been in court before, he's on the NCA list, he's got the credentials, he can describe himself as a consultant paediatrician with some legitimacy. So therefore, he just said, well, there you go, he's the kind of person we have in court all the time. If anything, this is a higher level of expert than we often have in court cases, when, as is argued here, they essentially need a tool set so that they can evaluate this more soundly. The text contrasts this then with the study, contrasts this with the US Daubert standard, which requires judges to assess scientific validity using factors such as testability, peer review, and error rates. However, it notes that even Daubert has produced inconsistent results in practice, particularly in criminal cases, and is not a perfect solution. I don't think we expect a perfect solution, but I think we obviously need to move towards a better solution, and Daubert would seem to be better than what we have now. Then it refers back to the Law Commission 2011, which proposed similar statutory reliability threshold for England and Wales, but of course this was never implemented. As a result, reliability remains conceptually vague and heavily dependent on lawyers' ability to challenge expert evidence. So it's all down to Ben Myers to expose Dr. Evans. He did a pretty good job of that, I think, with some support from probably some advice and arguments from Dr. Hull. But when he applied, you saw what happened when he applied to have Dr. Evans thrown out, when he applied it to be no case to answer. It was just, the jury can decide, you can cross-examine him. That's the adversarial system. Like it or lump it. So the Daubert standard that's been mentioned a few times in this document is a rule of evidence regarding the admissibility of expert witness testimony. A party may raise a Daubert motion, a special motion in limine, raised before or during the trial to exclude the presentation of unqualified evidence to the jury. The Daubert trilogy are the 3 United States Supreme Court cases that articulated the Daubert standard, beginning with Daubert versus Merrill Dow Pharmaceuticals, which held that Rule 702 of the Federal Rules of Evidence did not incorporate the Frye standard as a basis for assessing the admissibility of science expert testimony, and then later incorporating General Electric Company versus Joyner and Kumho Tire Company versus Carmichael, talking about various problems with judge expert testimony and gatekeeping. Just trying to create a better system for saying this person is an expert, this person is not an expert, this person is likely to give good expert evidence, this person is not likely to give good expert evidence, this is good expert evidence, this is not good expert evidence. And it's clear that in the British court system that is somewhat lacking. So the passage highlights that this adversarial model breaks down when defence experts are absent, as seen in the Lucy Letby case, where the prosecution evidence went largely unopposed. It argues that cross-examination alone is insufficient to expose complex scientific flaws, and that courts may instead defer to expert authority rather than critically evaluate methodology. Broader concerns are raised about judicial deference to expertise, especially when judges and juries lack scientific literacy, which is basically all the time. I can't see any situation where a judge would have scientific literacy because they have to study the law their whole lives. And I suppose you could have someone on the jury who has scientific literacy, but by the law of averages, it's going to be pretty rare. And it's always going to be a minority of people, if any. This can lead to reliability being inferred from an expert's status rather than demonstrated through rigorous analysis. The text suggests that addressing this requires structural reforms such as state-funded experts or independent expert registers. I think something that a lot of people have mentioned. Finally, the authors propose a Daubert-light reform targeted pre-trial reliability hearings for complex or disputed expert evidence. These hearings would require judges to assess methodological validity in advance of trial using structured criteria, e.g. testability, error rate, scientific support, but without rigid rules that could oversimplify complex scientific reasoning. Overall, the passage concludes that improving expert evidence requires more than accreditation or disclosure. It needs a more structured, transparent, and scientifically informed admissibility process, while still recognising that judicial interpretation remains central. And then the final section is judicial training in scientific literacy. As I just mentioned, a very serious problem for the court system. And this passage argues that improving expert evidence in criminal trials requires stronger and more active judicial scrutiny rather than reliance on adversarial testing alone. It acknowledges that judges are legal generalists, not scientists, but contends, drawing on Richmond, that they should engage with expert evidence in an educative and critical way rather than deferring to it automatically. However, this creates a practical problem. Without sufficient scientific literacy or institutional support, judges may struggle to identify methodological weaknesses or assess complex expert reasoning, leading to excessive reliance on expert authority. So it's again really the same problem, that once you have an expert in there, once they've been rubber stamped, once they've been vetted, once they've got qualifications, that the judge will tend to lean into that in the existing system. The text critiques the current CRIM, PR and CPD framework, which assumes that adversarial challenge will expose weaknesses in expert evidence. In practice, especially in complex scientific cases, this assumption often fails. While greater judicial gatekeeping could raise concerns about efficiency and overreach, the passage argues these risks are outweighed by the dangers of leaving reliability to advocacy alone. The proposed reforms aim to strengthen judicial capacity without undermining the adversarial system. First, judges should provide more structured and reasoned rulings when expert evidence is contested, explicitly explaining how factors such as methodology, peer review, error rate and alternative explanations influenced admissibility decisions. This would improve transparency, consistency, and the development of admissibility law. Second, the judiciary should receive greater institutional support, including training in scientific and probabilistic reasoning, and potentially access to independent scientific advisors in complex cases, with safeguards to avoid problems associated with court-appointed experts. The goal is not to turn judges into scientists, but to equip them to better evaluate expert reasoning. Overall, the passage advocates a model of structured skepticism where judges actively and transparently scrutinise expert evidence using clearer reasoning and better support systems, recognising that reliability cannot be ensured through adversarial process alone or rigid rules, but requires informed judicial engagement. So this is what we're looking for from Judge Goss in the court case. And of course, I've made this video recently that shows all the ways that his decisions went against Lucy Letby, and I do believe that was unfair. But also, he may be viewing it from the perspective of, ultimately, the adversarial system is great, this is what we do all the time, it's up to the safeguards and guide rails that are built into the adversarial system to deal with this expert evidence. It's not my job to do that. I just need to examine, is this a suitable expert in terms of the typical guidelines that we have? Yes, okay, well, he can say whatever he wants then. So I will finally read the conclusion from this study in full. Ultimately, the Letby case does more than revive long-standing concerns about expert evidence. It exposes a deeper structural problem, the absence of an adequate epistemic infrastructure within the criminal process to detect, interrogate, and contextualize error. Importantly, this is not simply a case of flawed expert evidence being admitted unchecked. Rather, it illustrates the limits of a system that relies on adversarial testing as its primary safeguard of reliability. Although Letby's defence at trial subjected the prosecution's experts to extensive cross-examination, it did not call independent medical experts of its own. The result was not a balanced contest of competing expertise, but a contest of interpretation in which the jury was required to evaluate complex medical opinion without the benefit of fully articulated alternative explanations. In this respect, Letby highlights the fragility of a framework in which contested scientific evidence may assume decisive weight in the absence of meaningful epistemic scrutiny. The analysis in this article demonstrates that this vulnerability is systemic rather than exceptional. Although the common law and procedural rules provide a coherent formal structure, they do not adequately address the epistemic challenges posed by complex scientific and medical evidence. Admissibility remains permissive, and the evaluation of reliability is rarely undertaken in a structured or explicit manner. As a result, the effectiveness of adversarial testing continues to depend heavily on the resources, expertise, and strategic choices of the parties. The reforms advanced here seek to strengthen rather than displace the existing framework by introducing more structured reasoning on admissibility, a proportionate pre-trial mechanism for assessing reliability, clearer expectations around accreditation and continuing expertise, and enhanced institutional support for judicial engagement with scientific evidence. Together, these measures aim to improve the transparency, consistency, and rigour of evidential evaluation while preserving the core features of the adversarial process. The continued reliance on adversarial challenge and judicial intuition as the main safeguards of reliability reflects a 19th century procedural logic that sits uneasily with 21st century scientific complexity. So I'm really glad to see them write that, because I've argued that many times on this channel. So to see two people who are very much more qualified and knowledgeable than me argue that is nice to see. Legislative inertia following the Law Commission's 2011 proposals has left English criminal law with a hybrid regime, part common law, part procedural directive, whose coherence depends largely on the variable confidence of individual judges. Comparative experience under Daubert further demonstrates that formal gatekeeping tests without deeper cultural change rarely transform practice. The real reform imperative therefore lies in cultivating what might be called epistemic literacy, a mode of judicial reasoning that is transparent about uncertainty, sceptical of expertise without being dismissive of it, and institutionally supported by mechanisms for independent scrutiny. Reimagining reliability in this way is not simply a question of procedural refinement, but of constitutional integrity. A justice system that cannot adequately explain why it trusts expert evidence risks substituting authority for reason. Only by addressing these deeper epistemic challenges can the law maintain both its integrity as a truth-seeking institution and its moral authority to determine guilt and innocence. So I'll do a brief summary of this paper. Essentially, it's doing around half a dozen things. The first thing is explaining how the existing British legal framework has been established, citing various precedent in doing so. It discusses why this framework can be problematic and some of the problems associated with it. It discusses alternatives to the existing system, often that are already operative in other countries. It gives an evidence-based opinion on what would be a better approach to such complex cases in the UK. It strongly argues that the way experts and expert evidence is selected and assessed is fundamentally flawed. And it argues that far too much trust is placed in both the credentials of experts and the ability of the adversarial system to scrutinise expert evidence. Ultimately, it concludes that the existing system is essentially not fit for purpose. So I really commend Amel and Sarah for this study or report or review. I think it's really exceptional, and it's very clear that they know a lot about the Lucy Letby case and have studied it in some depth and thought about it very clearly, and they obviously know the law inside out. So I think it's a very interesting investigation of the issues that surround the Lucy Letby case, and it's just another example of something we've established on this channel. The system needs to change, particularly the system around expert witnesses and evidence that is proffered by those expert witnesses. And if that's not clear after the Lucy Letby case, I can't imagine when it's going to be clear.